Good afternoon, ladies and gentlemen, distinguished guests. It's a great pleasure to be seeing you here today, speaking to you. And most particularly, congratulations, Jose, Jackson, and Martin, on the launch of your book, Arbitrating the Conduct of International Investors. Thank you for inviting me to offer some reflection on an issue that has become the subject of an intense public scrutiny and is of great significance to the arbitral profession. Let me start with a few words on the ongoing discourse on investment arbitration or investor-state dispute settlement that many of you in the room might be familiar with. But before I proceed, let me make it clear that the PCA as an institution does not have any position as to whether investment treaties should contain an investor-state dispute settlement mechanism. In fact, among the PCA's contracting parties, there are countries with an extensive network of bilateral investment treaties, BITs, and countries that have not concluded any such treaties. In our view, it is the prerogative of governments to select the settlement mechanism that they regard as most appropriate, taking account of their policy preferences and interests. And to the extent that states wish to consider new approaches to the present system of investment arbitration, PCA stands ready to support any such initiatives at the technical level, including by assisting states in designing and implementing efficient and fair mechanisms for the resolution of disputes with foreign investors. That said, PCA stands ready to support the development of new ideas, such as the one contained in the book, that can contribute to the debate on reform of ISDS. So that is what we are here for today. In the last few years, investment arbitration has been the subject of much heated debate. And while the arbitral profession has tended to perceive itself as engaged in the noble pursuit of international justice, public opinion has challenged that perception in various ways by painting a picture of secret tribunals engaging in parallel justice at the behest of corporate interests. States and competent international organizations such as the European Union, but also arbitral tribunals, have tried to respond to those criticisms in a variety of ways. I believe that arbitration itself is a noble enterprise, and I have a favorite quote. Arbitration remains the voluntary agreement of states or persons to submit their differences to judges of their own choice and to bind themselves in advance to accept the decision of judges so chosen as final and binding. This natural right of self-regulation is a precious possession of a democratic society, for it embodies the principles of independence, self-reliance, equality, integrity, and responsibility, all of which are of inestimable value to any community. End of quote. The promise of international arbitration as an effective means to diffuse political tension and avoid violence extended to disputes regarding economic affairs, disputes that we would call nowadays investment disputes. In fact, many of the first cases at the PCA were in substance what we would call now investment claims, claims relating to alleged unfair treatment of foreign nationals, such as the dispute between Great Britain, Germany, and France on the one hand and Japan on the other, as to whether perpetual leases to land granted by Japan to nationals of those European powers, exempting them from taxation, would still allow for taxes to building constructed on the leased land, or the case concerning seizure of real estate belonging to nationals of France, Great Britain, and Spain by the Portuguese government, where a PCA tribunal ordered Portugal to compensate the claimants. Sounds rather modern, no? As much as some of the fact patterns then and now resemble each other, the public perception of international arbitration has changed significantly. And that change in attitude seems to be a very recent phenomenon. Only a few years ago, a distinguished academic commentator still attested in unequivocally positive terms that, and I quote, the development of investment arbitration in contemporary international law has helped to consolidate access to justice as a principle of both customary law on the treatment of aliens and human rights law." End of quote. At the time that article was published in 2009, most members of the general public would have been unaware of the practice of investor-state arbitration and would certainly have had no particular view. That has changed. The sheer number of investment disputes has grown significantly. Investor-state disputes make up the single largest proportion of the PCA's docket, 87 out of 139 pending cases. The remaining cases are contractual claims involving a state, state-controlled entity, or international organization, and of course arbitration between states, the category of disputes for which the PCA was originally founded, which remains until today at the core of our activity. Today's criticisms of investment arbitration are wide-ranging, and I only note them not to be complete because they're only relevant for today's discussion to a certain extent. But the criticisms range from ISDS proceedings are secret and lacking transparency. Arbitrators lack independence and impartiality. Geographical representation in the system is unbalanced. Investors bring frivolous or abusive claims. ISDS constrains states' regulatory powers. Shortcomings cannot be corrected as there is no review mechanism. And then the final one that is relevant for our debate today, ISDS leads to lower environmental, public health and labor standards. Suffice it to mention Vattenfall's two claims against Germany, one relating to stricter environmental conditions for a coal-fired plant in Hamburg, and the other one challenging Germany's moratorium on nuclear power. And Philip Morris challenged Australia and Uruguay's plain packaging legislation for cigarettes. But this is also a common complaint against the numerous claims of mining outfits, oil majors, and large infrastructure projects who have allegedly sought to ride roughshod over the rights and concerns of local communities, and then claim compensation when local resistance ultimately prevails. The book launched today addresses this latter concern, noting that host state rights need not to be the first casualty of the investment arbitration regime, and the rights of their citizens neither. Being neither pro-investor or pro-state, this book is pro-investment, arguing that the disequilibrium between rights of the investor versus those of the host state or its nationals may be better remedied not by closing the one-way street, but rather by opening it to traffic flows in both directions and allowing claims by host states and their nationals. But before I elaborate on this idea, I would like to note that this last criticism is by no means limited to investment disputes. A comparable criticism could be made of disputes in the area of business and human rights. The United Nations Guiding Principles on Business and Human Rights, adopted by the Human Rights Council, have assisted in defining the roles and responsibilities of businesses and governments with respect to the protection of human rights in the course of activities undertaken by business enterprises. These efforts address what is perceived as a systemic absence of effective recourse for local populations affected by such multinational business activity. Access to national courts might be barred by jurisdictional issues or simply their capacity to handle such cases. Inequality of arms or the lack of reliable enforceability on an international level may also discourage their use. As a result, alternative dispute settlement mechanisms such as arbitration and mediation are increasingly being explored to enhance the access to justice of affected stakeholders in business-related human rights disputes. Recently, the PCA was asked to appoint arbitrators and act as registry in two business-related human rights disputes arising under the Accord on Fire and Building Safety in Bangladesh. This so-called Bangladesh Accord is an agreement negotiated with the assistance of the International Labour Organization between apparel brands, retailers and trade unions to establish a fire and building safety program for workers in the Bangladesh ready-made garment industry. It also provides for arbitration in case of dispute. And the PCA has also been involved in similar private sector initiatives in the area of certification of carbon credits and protection against damage to biodiversity from genetically modified organisms. Reflecting the stance of this book that it is a good thing for dispute resolution mechanisms to exist, regardless of whether they are availed, the PCA has been taking initiatives to provide better equipped service in the emerging field of business and human rights arbitration. In the particular cases I just mentioned, the PCA agreed to act as registry at a reduced rate. Realizing the need to be able, in respect of future cases, to identify arbitrators and mediators with particular expertise in the business and human rights, the PCA has been working on a proposal which will hopefully be supported by its contracting parties to establish panels of arbitrators and mediators with such expertise. The existence of these panels would allow parties choosing to arbitrate disputes in this field, as well as the PCA Secretary General, to more easily identify qualified arbitrators and mediators, improving the efficacy of such proceedings. I dare say that the individuals who might be identified in that context may also be suited to take on the cases envisaged by today's authors and contribute to addressing the aforementioned concern over the diversity and profile of decision makers. Let me now move on to the topic of today. The book being launched today, does it contribute to this ongoing debate about the future of investment arbitration? How does it do that? The authors of this book present some important ideas on ISDS reform, which they claim that in the right hands should result in an increase of more sustainable investments worldwide. One of the book's premises is that, as in any commercial relationship, a sustainable investment is only possible where a proper adjudication mechanism is in place to govern the conduct of the actors. A local population fearful of being adversely affected and at the same time without access to effective recourse may consider that it has no choice but to oppose an otherwise promising investment initiative. This is an equally unenviable position for a state who is effectively asked to take sides between the investor and its own citizens, as between the goals of economic development and social protection. To that end, the authors note that in the absence of an international forum, the host state and its nationals are left to seek remedy in their own national courts, or, where jurisdiction may be established, in the courts of the investor's home state. Finding that this default localization often yields unsatisfactory results, this volume advocates for the position that all stakeholders stand to benefit if conflicted investment initiatives are submitted to an effective adjudication mechanism. They argue that it is the best solution to prospectively overcome mistrust of each other's conduct, and the best way to finally resolve actual conflicts that may affect the viability of an investment initiative or the continuity of an investment operation. Yet, taking account of the significant criticisms of ISDS in its current state as a forum only for investors' claims, the authors propose a range of models with which the ISDS regime could be turned in a centralized forum for all claims relating to a given investment project. Ultimately, this book aims to open our minds to a rethinking of the basic question of access to justice by both state nationals, by host state nationals, attempting to create a solution for the choice between economic benefit and the public interest. In essence, this volume serves to illustrate how investment arbitration may be availed to achieve increased investment flows and improved access to justice. It serves as a comprehensive guide for those who might wish to reform international investment law from within by allowing for the arbitration of claims submitted by the host state and its nationals. The success of responsible investment initiatives requires access by parties concerned to a dispute settlement mechanism that is empowered to render a binding result. As the authors note, success does not require that such mechanisms be availed, but it does require that such mechanisms exist. Thus, this volume finds that the soundest solutions to legitimate questions raised in recent years may result from introspection into rebalancing the regime by a return to its origins, a return to the mutuality of access that is in arbitration's essence, and a natural evolution of the mechanism conceived by the founders of the ISDS system many decades ago. This volume is conceived to offer the requisite toolset, the idea of which was conceived with the following motivations: to propose reforms designed to achieve broader access to justice in the event of international investment conflicts. Second, to propose reforms that open the powerful mechanism of investor-state arbitration to a broader range of stakeholders in international investment. And third, to achieve improved results for international investors and their home states, as well as host states and their nationals, by offering tools for greater certainty and finality in the law of international investment. In conclusion, I'm sure that the volume will contribute to the academic debate, but even more, I hope that some of those at the front line of ISDS reform, whether as practitioners, government officials, lawmakers, private sector economic actors, and private citizens alike, take inspiration from these ideas in crafting the future of international investment law. And with this, I would like to pass the floor to Eduardo Silva Romero, who is the moderator of the panel and who will introduce the participants. Thank you.
Thank you, Mr. Secretary General, and thank you for hosting us today in this beautiful place. Ladies and gentlemen, good afternoon. The idea of this panel is the following. The people at the respondent table here will be making comments on the book and on investment arbitration generally. And after each of us makes some comments, then the people on the claimants, at the claimants table, the authors of the book, will respond to the different observations that we will make. First of all, Cherie Blair QC will give us her remarks. I must say that Cherie Blair doesn't need to be introduced to anybody. We know her. In any event, I received her CV, and I should say that she is a barrister. She's an international arbitrator. She is the head of a law firm, Omnia Strategy LLP, and from that platform she represents states and corporations in very complex dealings and disputes. I'll stop here, and I'll ask Cherie, please, to give us her comments.
Well, thank you for this opportunity, and thank you for allowing me to have read the book in order to comment on it. My only regret is that I didn't have the book 2 weeks ago, because a week last Monday, I was appearing on a panel where I was commenting about the proposal for the European Multilateral Investment Court, where I was speaking against that idea. And if only I'd had the book then, I would have had even better arguments to put forward to express my doubts about how actually the court would be a step backwards and would undermine both the flexibility and the acceptability of what we have at the moment, which is a system based on arbitral tribunals chosen by the parties and which provides an international forum for disputes which can then be internationally enforced. And I think the European Multilateral Investment Courts represents a fragmentation of that system into regional bodies, which I think actually is a step backwards, not a step forward. And I think that the book in particular is very timely, because at a time when the system is under threat, through people who, because of faults in the system, and there are faults in the system, have, perhaps through not fully understanding what can be done with the system, attempted to change something which actually works very well and could work even better with the sort of imaginative improvements that the book suggests. And I definitely agree with what the book says when they say we must learn from the past to improve for the future. If we go back to the very roots of arbitration, as we do in the book, it's very clear, it comes out very loud and clear from your introductory chapters how the initial impetus for such dispute resolution was founded on the basis of reciprocity. It wasn't simply to protect investors, as sometimes you might think if you read some of the criticisms. It actually took into account the interests and expectations of both investors and states, and actually assumed that an international independent dispute resolution system would be of benefit to both. And indeed, the report of the executive directors about the ICTY Convention actually emphasized that states and investors were permitted to bring proceedings, as you point out. But that is actually not what has happened in practice. As jurisprudence became more dense and cases became more complex, we've actually seen the shrinking of the states' rights, or at least the perception of the shrinking of the states' rights, and the expansion of investor rights. And so we find that universally, almost, states seem to be the respondents, so always on the defensive, and facing claims from investors that seem to result in larger and larger awards. And this is inevitably seen as a negative consequence for the state, because people see taxpayers' money, instead of going on much needed schools or hospitals or infrastructure, into damage awards to foreign investors, often huge multinational corporations. And I absolutely agree with the Secretary General. Cases like the Philip Morris case, or cases like the German cases you referred to, hardly improves the reputation of the system. Bearing in mind, by the way, that the Philip Morris case actually went nowhere. But there may be many people involved in the investor-state dispute world who might have wished it had never started, because it has been used as a very big stick to criticize a system which we would be foolish to ignore. That doesn't mean that by not ignoring it, we lose sight of the origins and the reasons why actually this system we have already is both flexible enough and responsive enough to provide answers to the problems of today, and not simply answers to the problems of yesterday. The system actually is very adaptable. Its fundamental characteristic is its flexibility and its ability to evolve. And that's why, as the authors of the book recognize, we can evolve this model into different developmental avenues for ISDS to go. And of course, as someone whose background for many, many years has been in human rights, as the Secretary General said, this whole question of business and human rights, which is a topic of the 21st century, the idea of the corporate global citizen having obligations as well as rights is very much a topic of our day, and we can see how arbitration provide a very useful mechanism, growing organically rather than imposed from outside, to deal with these tricky questions of how do we balance the desire for inward investment with the need to ensure that society as a whole, the host state as a whole, voice should be heard, and that society should be able to change to respond to modern needs and modern expectations and modern standards that we see in the global trends. I wanted to give you 3 examples of how we have seen how it is capable of catching up. The first one is the fact that we are now beginning to see states counterclaiming for business and human rights breaches in investor-state arbitration. And the recent ICTY case of Basser, I hesitate to say whether my pronunciation is right with so many people who know the pronunciation better than me, but Basser in Argentina in 2016 shows an evolution in the willingness of arbitrating tribunals to grasp these business and human rights principles. That was a case about water and sewage services provided by the claimant in Buenos Aires, a concession given in the early 2000s. As we all know, Argentina had a financial crisis in 2002, and frankly, Argentina is a state that is very much featured in being penalized with huge awards in this area too. And the state took emergency measures, ending the claimant's concession in 2006. That actually not only led to financial losses, but also to insolvency. So the claimant filed for arbitration, and in that, Argentina raised a counterclaim, which in itself is unusual. And Argentina's counterclaim says, because you, the investor, didn't put enough investment into the concession, you led to a violation of the human right that our citizens have to water. Claimant said, well, no, sorry, that right, that's nothing to do with us, we're just a company. That's a government issue, and as you know, under business and human rights, governments are the ones who protect human rights, but corporations have to respect them. The tribunal said, no, you can't just wash your hands of this simply because you're not a government. And it said, we're not going to accept that there aren't obligations imposed on you, the investor. However, having said, it was open to arguments about human rights law in such tribunals. They didn't actually allow the counterclaim to succeed, so it didn't go so far as to actually succeed, but nevertheless, it established a principle that these factors can be regarded in investor-state arbitrations. And the tribunal actually said, international law accepts corporate social responsibility as a standard of crucial importance for companies operating in the field of international commerce. So the tribunal found the rules of international law, including the rules that govern human rights, can't just be ignored. The claims under bilateral investment treaties aren't some sort of self-contained world that isn't affected by the broader body of international law. And just as today, companies and investors are much more interested in sustainable development and sustainable investments, and therefore concerned with things like the Ruggie principles. So too, if a company, in the way it conducts its business, is being cognizant of that, how can it, when it conducts an arbitration, say, oh, well, that's just what we say when we're outside these arbitral tribunals. Inside these arbitral tribunals, we don't believe in the principles of human rights at all. Not a very attractive argument, and the tribunal quite rightly accepted that there is a possibility for these matters to be litigated there. I think it's a very interesting example of your third direct claims model, and I think that it is something that you have touched upon in the book, and I'd love to hear your thoughts about it in more detail. And this, I think, would also really help with some of the criticisms of the current system, which certainly to the public at large seems to be all about the rights of the investors and says very little about the obligations of those investors. I think we're seeing that this is in fact not a one-way, but a two-way street. The second example, of course, you, Mr. Secretary General, touched on in your opening remarks, and that is the great work that the PCA has done in helping to litigate disputes under the Bangladesh Accord arbitration. And I was going to say a little bit about it, but since you have said something about it, I'll say no more than this, that when I learned from you today, I thought the two cases had been settled, but it turns out that perhaps it's not quite yet brought to finality, which to some extent makes me quite happy, because I would love to know, it would be very nice to know the reasoning and how, if this whole area is to develop, you need to have some kind of transparency, at least about the outcomes of these disputes. So I won't, given time, say too much about that, but simply to say how this shows the flexibility of arbitration and how it can respond to the needs of the times. And then finally, there's a UN working group on business and human rights, which is a 2017 proposal, which says arbitration is the right mechanism to resolve business and human rights disputes, and says we don't have to reinvent the wheel. We already have UNCITRAL arbitration rules. Let's adapt them. Let's see how we can make them work in this new context. And we look very much forward, I think, to this year, seeing the first proposals coming out of the committee, led by Judge Bruno Simmer. It's going to report later on. So I think, again, it shows the real key about why arbitration is such a useful tool, because it has that flexibility to respond quite quickly, as the authors have suggested, to new demands and new benefits and new issues which arise. So we get a universal jurisdiction in an arbitral tribunal matched by its universal enforcement under, as the book also explains, either the ICTY Treaty or indeed the New York Convention. And of course, that issue of enforceability is one of the greatest advantages of arbitration, because it does allow enforcement across the world. And the idea that that enforcement could also be transfused into human rights law as well, I think is a very attractive proposition. So, to some extent, I think the arbitration community has been guilty of failing to talk to the public in a language that they can understand about why arbitration came about and what its advantages are. For too long, the community has tended to talk to each other based on academic learnings about the cases. Most of those cases, in fact, have been about investors, often achieving large sums of money against states. So perhaps we shouldn't complain, when the public get the impression that that's all it's about, and that it's some sort of special law for a special community who, just because they happen to have money, therefore have special privileges that the poor in the cities and in the villages across the world don't have. So we need to say, no, that is not what this is about. This is a form of justice which truly is for all, provided we can give them the mechanisms to achieve that, and provided that we build the structures and the knowledge and the ability among the arbitrators and the advocates to use this system for the benefit of those who have felt left out, which is why I very much welcome what you, Secretary General, said about the idea of having specialist lists for this, because you have to have a particular sensitivity to the needs, not just of the investors, but of the human rights, environmental, and governance issues, which are so important. They're so important for us all, but they're particularly important when you're talking about litigation against a state. Litigation between two private individuals is, to a large extent, up to them. But when you talk about litigation between individuals and the states, and a state, or states and other states, then you've got to understand that there are certain principles, which means it can't be a wholly private matter. And that includes issues like transparency, it includes issues like access, and it includes issues like sensitivity to the broader economic and social context in which we all live. So thank you for showing how arbitrating conduct of international investors can really reach places which otherwise a national system on its own couldn't do.
Thank you, Cherie, very much for your comments. And now, before giving the floor to the claimants, let me introduce them very rapidly because I take it you know them, but that's my role. First, you can see José Daniel Amado. His friends call him Pepe Amado. He's the founding partner of his law firm in Peru, from my perspective, the best law firm in the country. And he has practiced law in both corporate law and international arbitration. He has participated in the most important arbitrations involving Peru. He is a former graduate of the Catholic University of Peru, Harvard University, and he was a visiting fellow at the Lauterpacht Center for International Law in Cambridge. Then we have Jackson Shaw Kern, who is a lawyer. He has been counsel in many arbitrations across Africa, Asia, Europe, and the Americas. He's an alumnus of McGill University in Canada, and also was a visiting fellow of the Lauterpacht Center in Cambridge. He's off counsel to the Addis Law Group LLP, and I had personally the pleasure of seeing him in action a few years ago. And last but not least, Martin Doe, who works in this house at the PCA. Martin is senior legal counsel at the Permanent Court of Arbitration, and he administers and is secretary to very important arbitrations all over the world, state-to-state or investor-state arbitrations. He is also a lawyer, of course. He knows the common law system, the civil law system, and something I should underline because it's a curiosity. He holds a degree in biochemistry from McGill University. So that's That's curious. Gentlemen, you have the floor. Please.
I just have really one very brief comment in response to what we've heard from Cherie. And first of all, thank you for your very warm reviews of the book. And indeed, you concluded by suggesting, what we're trying to do here is to show that a new world is possible. So that's our modest hope. The only comment that I have in response, a little bit later, I think it will fall to me, I believe, by one way or another, to enter into a little bit of technical detail about the mechanisms that we're proposing. And Cherie used the phrase, we are not reinventing the wheel. It's not necessary to reinvent the wheel. She is, of course, exactly right. And in showing the diagrams that I have compiled and which, in fact, feature in the book itself a little bit later, I hope to illustrate that point. It is not necessary to illustrate the wheel, but in fact there are some simple engineering solutions that are well within reach. So, thank you again.
Martin?
Sure. I think the one comment that I might react to in Cherie's remarks there was about the current proposal by the European Commission of an investment court in a multilateral system. And I think the advantages are clear, but I think you've just highlighted what is the often forgotten downside, which is starting to erode the flexibility, the autonomy, those characteristics which are inherent to arbitration. And in fact, one of the fears that we communicate in the book from attempts to reinvent the wheel, as Jackson has just put it, is that what you will see is those with sufficient bargaining power will just choose to contract out. They will find a way to escape that forum and move into the forum that they are indeed familiar with, comfortable with, and serves their interests insofar as they have the bargaining power to do so. And so in some ways, some of the reform efforts may backfire if they go a little bit too far in precisely reinventing the wheel.
Pepe.
Thank you. Maybe I will just add to what Martin just said, that this, I believe, that this whole initiative of having investment courts in general, which is not only European, it's also happening elsewhere, in my opinion, and I believe that is an opinion that we three authors share, is like deleting 100 years of arbitration from one day to the other. Precisely the purpose of arbitration is that the parties participate in appointing the people who will resolve their disputes, and that dispute will be final, clearly. So those advantages that arbitration has, which, as the Secretary General pointed out, continues to make it, well, the phrases that he read continue to be valid, even though we know that they come from a long time ago. Everything that has been accomplished in arbitration will be completely upside down if a group of people, no matter their credentials, no matter how informed and instructed they are in the matter of investment arbitration, will be reviewing something that the parties chose to put in the hands of an arbitration tribunal. So definitely we are also in disagreement with that proposal, and we try to make it, even though it's not part of the main issues in the book, we try to indicate that the way to resolve an arbitration-related issue is by studying and working on arbitration, as Cherie was saying before, on reviewing things that had been said before, things that we can learn from, and that is basically what we are trying to accomplish with our own proposals. I don't want to put our proposals against the investment court as such. Our proposal stands on its own, and it is a proposal. But I think that the interesting part, if I can try to make some of what Cherie said, a statement that would be also mine, is that what we're trying to do here is reshaping and reforming arbitration from within. And that is certainly the task that we have been working on, that is reflected in the book, as we'll be seeing throughout this session.
Thank you very much, gentlemen. The good news, as far as I understand, is that UNCITRAL is no longer supporting, at least as before, this idea of the investment court. And now the new philosophy of UNCITRAL seems to be pro-investment arbitration, and hence the book might be a great help to the new Secretary General of that institution. So I'm sure she already has a copy. It is now my privilege to introduce our next commentator, who doesn't need introduction either, Judge Koffi Afande. As you know, Judge Afande was a member of the ICTR, ICTY Appeals Chamber in The Hague, here. And he has been an academic all his life in the field of criminal law. He wrote his thesis on a topic of criminal law, which was juvenile delinquency in Togo, France, and Germany. And he received the 5-year award Dennis Carroll for his thesis, an award which is given by the International Society for Criminology. He has been very active in many UN missions, and being someone who knows what justice means, he can help us with his comments on the book. Monsieur le Juge, you have the floor.
Thank you. After all that has been said, I asked myself if I have anything to add to that. I read the book, and I think I already confessed it elsewhere that it is a book I read, and I regretted not having been the one who wrote it. So, but from there, the first impression which I have is, we have been saying it since the beginning, that arbitration system is not meant, in fact, to protect the investor. It is to create equality, mutual respect, and so on. And if we look at it in that perspective, which you clearly explain also in the book, but I regret that you came to the human rights issue at the end, not at the beginning, I was very pleased to see that you are bringing investment and arbitration back home. Because if we say that from the beginning on, it was to create equality among parties, that is a human rights principle at the basis. Because we read already in the big international legal instrument that we are all born equal and we deserve equal protection by or of the law. That is where investment process came from, and also arbitration is meant to put that right into effectiveness. The other ones are just how to make sure that that principle of equality of protection in any kind of litigation or conflict is ensured. And that is where I see that this book, you call it, it is a provocation, but I say it is a very human approach of what has been said or seen from outside as the right or the law for privileged people. Ms. Blair was saying it has to be brought also to those who are in the villages, who are, we don't know it most of the time, they are the first who are interested or concerned or who feel the impact of investment on their daily life. Then if arbitration is meant to ensure that mutual respect, equality in rights, should it not be applied to all participants or actors in the whole process, regardless whether the person is investor, whether the person is host state, or if it is national of host state, or also national of home state. So why am I saying this? I believe if we talk about access to justice, as the Secretary General mentioned it at the beginning, justice is not meant only for a category of people, but it is meant to be covering all actors or participants in specific operation in which justice is being addressed. I am saying this because I come from the other part of the world where we don't have the privilege to be called investors, but the investors come to us. And we are wondering, and that one I didn't see it in the book, what is the proper definition of the investor? Who is investing where? If investment means only bringing money, it may be difficult to reach the wonderful approach of the book. It has to include also a kind of recognition of what the other is bringing in. The risk is there that if we don't consider whether natural resources which are being exploited and so on, also as an investment, as something which is being paid in compensation of the money which is being brought, we are not putting the participant on equal footing, and then we may not ensure that equality in the system of justice which we want to reach. But then, if we come from there also, I see you have been very careful in saying the importance or the willingness to really reflect international human rights law in arbitration, negotiations, agreements, or treaties. So you said it very wisely that it is being mentioned in the, maybe in the preambular part of the treaties and not really in the operative part, which is true. Why is it like that? Is it because there is no real belief that human rights law should be applied in arbitration? Or is it out of caution? Because that is a box, when you open it, you never know where it ends. I would rather go for the second, because as we say, arbitration is based already on international human rights law principle, equality. Then, human rights law has also been absent for a long time in many, many fields, but progressively it has gained colors. We see it in politics, we see it now in fight against impunity. Many fields which were closed, and we don't have any drop of international human rights law is being now overflowed by that law. Is the reason why the negotiators of agreement or treaties are being cautious in clear terms, but again, we have advised a wise and simple way to go about it in trying to explain what could be the scope of the applicable substantive law applicable in terms of international human rights law, which I also find very practical. I was proposing that you go for a French version, French translation of this book, because I know for many of us, which we call ourselves Franglophones, we will be very interested in seeing the other version. But then one point is important is if we see, not that we assume, we see it because it is a reality, that there is a need of arbitration system helping also to prevent some conflict. Not only arbitrating conflicts between parties, but also creating conditions, maybe it is futuristic what I am saying, but creating conditions to avoid having those conflicts to be resolved. I can give you some examples, or only one because we are running out of time. Most of the time, many of the agreements, if I may call them so, are made outside the scope of arbitration system. You see the investor going to the government, meaning the home state, calling on phone someone in the host state, and the agreement is done. Since there is no writing, we don't know what is the content of that agreement, and no arbitration system can handle that. And it goes that far that preventative or prevention mechanism, which arbitration can be so absent that we sometimes come to violation of human rights. We have big conflicts in Africa nowadays, which are only consequences of those agreements which were not even negotiated, but which were imposed on some authorities, and there is no way for them to claim anything. Most of the time, government which want to claim anything is overthrown by a coup d'etat and replaced by another one. That is a gray field where I see we can do something to make what can be possible to bring it also into the field of arbitration. Another thing is your belief is my belief also, that arbitration be built on human rights. But if we see the reluctance in going there, there is also a new principle which is emerging. Not everyone believes in it, especially Africans, they don't believe in it, but they are applying it on a daily basis. It's what we call responsibility to protect. Meaning, in the context of negotiating investment, whether bilateral or multilateral or anything, agreement or treaty, countries should bear in mind that they have that responsibility also to protect. It is true that the scope of that principle is limited now to only 4 big crimes, which are genocide, aggression, crimes against humanity, and war crimes. But since we see that in many cases, those crimes are the consequence, direct consequence from those investment processes which are not clear, it means that trying to correct it is also a kind of protection of the population so that those kind of ethnic cleansing also do not happen. And that link, which make a little, or depending on the perspective, a shift to criminal responsibility may not be easily accepted in the field of arbitration, I know. That's the reason why I'm rather thinking of it in terms of preventative measures to be taken into account. Each state, whether home or host state, should have in mind during those negotiations to reach an agreement or a treaty that they have also to protect the populations in both countries. I was thinking further than that. You have a kind of competition which is sometimes disloyal among potential host states. If the investor goes to state A, which puts more requirement obligations on the investor, then it goes to B, which is more amenable or accept a lower standard of human rights law to have the investment. Could it not be a possibility also opening a kind of, action for those who, because they have requested a higher standard of human rights, have been denied the investment and to be given to someone of a lower standard? Could it not be also a possibility for them to be part of the arbitration system? Another point is, if we agree, you may disagree with me, that crimes which are being prosecuted at the international criminal jurisdictions are most of the time or sometimes direct consequences of those investment processes. Will it also not be that arbitration jurisdictions have a role of consultative, I don't know how we will call it, to the International Criminal Court? Because they also know to understand. I have been sitting in one. They need to understand the reasons which are behind the fact which they have to try it, because it has a huge impact on the mode of liabilities to apply. Sometimes we prosecute not the right people, but the wrong ones. Just to tell you a story, when I was in the Security Council, we were negotiating a resolution on natural resources in terms of exploitation of natural resources and consequence on international peace and security. The link was clear that it's not the natural resources as such which are the threats for that peace and security, but if it is the strategic value and the financial value which they have, which becomes a kind of competition between some countries, which leads to that threat to peace and security. But because that link is leading to the right people, you can be sure that that resolution has never been discussed until the end, and we left the draft as it was, just to warn you that you are going into a field where you will be facing very strong resistance, but I see that you have enough courage in the approach of the book I say I like the book. If you can scratch one of your names and put my name also in it as if I was one of you, I would be happy. So these are other aspects which I think your book will lead people to think of, because I didn't really think of these things. Then you wrote something, you think you stop it at one point, but you are triggering other reflections in people, which is good. But if you can also be prepared to assist those who, based on your book, will also nourish other expectations, that you assist them also, meaning I'm calling you to write the continuation, meaning another book to respond to complete this one. That will be my advice to you. This is a very good book, and I like it. Thank you.
Thank you very much, George Afande. Any reactions from the authors? José Daniel.
Thank you. Well, first of all, let me thank Judge Afande for his very nice and very kind comments on the book, and more importantly, on what the book can lead to, which is frankly something that the three of us have discussed many times, and we do believe that nothing would make us happier than seeing other people reaching the next level into what we are trying to do here. Let me just very briefly comment on Judge Afande's statements on prevention, which I think are critical. And we try to make that point in the book. Of course, it is not the core message, but it is part of the most important messages. That it is also our understanding that including certain rights to claim by the state or by the host state populations on certain projects, even if no arbitration ever takes place, should be something that works in favor of a sustainable investment. Because what we have today, and I also come from a country far away, we have today is that usually, the population, when there is an issue, has to decide between trying to go to a local government, which probably, perhaps they don't trust them. They have to go to the local courts, which perhaps do not work as fast as they want. Or, quite unfortunately, sometimes they get into some political riot, for instance, against a project that they need. And that's why we're basically in agreement with the words of the Secretary General in his introductory remarks that this book is pro-investment. We think that certain investments could happen if arbitration provisions would have been in the agreements, allowing people to make claims. Again, even if those claims would never be made, because that, and I can tell that, I can say that as a corporate attorney who have represented corporations all my life, that is something that may change the picture, because a large corporation that comes to one of the emerging countries and really signs an agreement that would make them liable under certain circumstances, for instance, not comply with a certain human right. Let's say water rights related to local population. If there is something in writing that would take them to international arbitration, then I think that the situation could be different. And that is why we fully agree with your statement that there is a lot about prevention that may come from the type of ideas that we try to include in the book.
Can I say something? I think you're right, Koffi, that it's difficult sometimes to get states as well as corporations to sign up to these rights and obligations, because some of them, frankly, don't really want to take on those rights and obligations, because they think that being a leader of a country means it's all about me. And actually, as Cyril Ramaphosa said yesterday, it's actually all about being a servant to the people. But in relation to companies, I think that we are seeing a trend, a movement away, and there is a pressure now on companies to behave more responsibly. And that pressure partly comes from the market, because today everyone is much more aware. You can no longer say what goes on in the DRC stays in the DRC, for example, because communications are such that people know, consumers know. It's things like the Blood Diamonds and the Kimberley Accord. So there's pressure from the people who actually purchase the ultimate goods, which companies have to respond to. There's also peer pressure, because we're now seeing groups of companies in different industries, whether it's in the mining industry or the garment industry or the diamond industry, coming together to set up best practice. And you can't discount the fact that if you're involved in that industry, to be known as someone who is a good player in that industry is important. So that's another pressure that's driving companies that way. And then actually, countries themselves can do something about it because of public procurement contracts. And it doesn't just have to be the host country. The home country actually could also say, we're not going to give any of our contracts to companies that sully our nation's name. You could say that, couldn't you? Why not? And so I think that in today's connected world, there is pressure that is certainly forcing corporations to behave better. And that pressure also, in the end, is also working on states. But we do, on the other hand, have to be realistic about the other side, because it's all very well talking about having human rights being involved in arbitration, opening up arbitration to people who have not traditionally gone there, but how are they going to pay for it? So we also have to think about this question of the inequality of arms between rich corporations and poor countries, or rich corporations and poor villages in a country whose village has been ruined by pollution. And I know there's a special fund here at the PCA to pay arbitral costs of poorer countries. Is there a case for also setting up some kind of fund that could also help in these kinds of disputes? I mean, it's certainly something I think that needs to be talked about and considered, and that fund doesn't only have to come from the countries, it could actually come from the business community as well. So I think these things, again, would give that opportunity. And I do think that this idea of being able to choose your arbitrator is a very important part of that process, and can make disempowered communities feel more ownership of a process. I was thinking while you were talking, Koffi, about there's been long-standing litigation in the British courts about the Chagos Islands. You probably, some of you may know, and they keep going to the British courts, and generally speaking, they keep losing. But I sometimes feel that don't know, maybe there would have been more dignity if they could have had, it's almost a continuation of the colonial process, if you like, that in the end they have to come cap in hand to the host country court to ask for some justice. Whereas, in theory at least, if you have an arbitration system where you have an input into the arbitrators, you may feel that you've got more of a, you can perhaps select some arbitrators who have more of an understanding perhaps of the wider issues that you're talking about. So I think it could be a very powerful mechanism. We just need to think more creatively. I partly think one of the reasons why the investors have done so well is because they've always had the money to pay for the lawyers to think creatively. But actually, you know, lawyers can think creatively, not just for investors. They can think creatively for governments, they can think creatively in relation to victims of human rights abuses. And we simply need to be able to have the resources and the resources to fund that and the mechanisms from which those claims can be made. And you're showing that one of those mechanisms can certainly be arbitration. So I think we should feel this is an exciting opportunity.
Any other comments? Mr. Doe.
There we go. I sense that fundraising has been added to my job description there. Thanks, Cherie. I think that's a fantastic idea. And we'll see how that idea might develop into practice in the future within the International Bureau. But I wanted to dovetail on some of what
it'd be better use of the money than the money setting up a European investment tribunal, wouldn't it? Because if anyone thinks that's a cheap option, they're kidding themselves, aren't they?
No comment. just to take no position as our Secretary General put forward there.
It's okay, I can say.
And thank you for doing so. I just wanted to dovetail on some of those comments. I mean, Judge Afande, you were saying the purpose is not to provide for investor protection. The purpose is to try and provide for an equal footing. In fact, that is, or that implies trying to widen recourse, to trying to provide for greater access to recourse. I'd take it one step further and to say the ultimate purpose of providing for equal footing is supposed to be promotion or at least facilitation of investment activities in different states there. And this, what we've tried to do is try to think of where do all these interests of investors, host states, and their populations converge to see that as not just bare investment protection come what will, but or investment promotion come what will, but the promotion of responsible investment. The promotion of investment by those who are progressively subscribing to these corporate social responsibility ideas, business and human rights ideas that are developing. And I think the way Cherie was characterizing it, that's almost where you do start to achieve this conflict prevention in the sense that having host state populations be confident that they will be provided access to recourse. They may not feel the need to be opposing investments up front or proactively litigating to try and essentially get in before the door closes. And in fact, that is where I think this is attempting to make that first step into into providing a premium on responsible conduct by investors, so that you are in fact giving them that extra something for good conduct, for responsible conduct in their investment activities. And so not just equal footing, but you are actually providing the premium to those who deserve it overall.
And just to contribute a few words of my own, and perhaps to make this a little bit more vivid, I could put it this way. I think that each of us has seen instances where we've sort of adopted we've tried to forge this term of art in our book, host state nationals. We've seen instances where host state nationals have become sufficiently educated, sufficiently sophisticated, that they say to themselves, you know, look, we know that if things go wrong, we don't have any effective recourse. So, you know, the investor's money is on the table. It might bring all kinds of development and benefits, but we know if things go wrong, we're on the short end, so to speak. And if we can use these mechanisms to give them a little bit more confidence, I think that the future of more sustainable investment is a bright one indeed. Second very brief comment in response to one of the points made by Judge Afande. And I'm going to offer a defense against one of his points, or perhaps it's more of a rejoinder, and it's a little bit coy. You said you regretted that human rights was mentioned only very late in the book. To me, the entire book is about human rights. And what I mean by that is, heretofore, the jurisdiction of investment treaty tribunals really has not comprised the adjudication of human rights questions. We heard briefly about the Urbacer case from Cherie. Maybe, you know, that's beginning to change, but for the time being, that case is something of an outlier. So the first part of the book, everything that leads up to chapter 5, is for purposes of establishing the jurisdiction to then adjudicate the substantive human rights. So it's all about human rights, to me. Thank you.
Koffi has right to reply.
Yes, I thank all of you for the comment and the additional statement of Ms. Blair. What I want to say is, when I say that the human rights issue came at the end, I am not meaning that the whole book is not about that. All your approach since the beginning was to reinvite human rights feelings and approaches, but the conceptualization or the incorporation of the existing rules comes only at the end. That is what I wanted to say. It doesn't mean that you exclude it and you handle it all at the end, but you make it more real and more convincing at the end. Because if I go to someone, I say, yes, we need to ensure the mutual standing in a process, in arbitration. No one will understand clearly that that is a human rights issue. But you said it at the end. Meaning you have it from the first word, even the one before the first word, until the end, but it was more emphasized at the end. It is maybe the tactic of the scorpion, which has the more dangerous part at the end of the body. So, it's not bad at all.
I'm laughing because my sister is in the audience, and there are some anecdotes involving scorpions in West Africa when we were small children. So that's a very vivid one for her, I'm sure. Thank you.
But thank you, gentlemen. And now it's my turn to give you some comments on the book, and I apologize. You will have to suffer for a few minutes. I enjoyed reading the book, and as you know, I have written about it, and you will see what I say when it is published. But I can anticipate some of the ideas now, and the reading of the book really made me think of 5 series of problems that I think the book is tackling, and is tackling them pretty well. The first problem is that the discussion today about investment arbitration is ideological. What we read and hear about investment arbitration come from ideologies that are not analyzing the system in an objective or neutral manner. There is a sentence in the book which is being relied upon by Professor David Kern in his introduction, which is very telling. You say yourself in the book the following: reform is not forced in rage and frustration. What is going on about this investment court in Europe, many criticisms that we hear about investment arbitration come, I would say, from ideologies which create precisely this rage and this frustration. And out of those sentiments, the proposals that we are seeing are defective, such as, I think we agree, the investment court that the Europeans want to create. What are those ideologies that I feel are killing the system? I think there are many, but there are two extreme ideologies which are very damaging. The first ideology is the one which puts into question the legitimacy of arbitration to be employed to adjudicate investment disputes. The question this ideology puts is, for instance, how could a European arbitrator understand the political history and idiosyncratic issues of some Latin American or African countries? Or even more generally, the question is, how could three private persons, called arbitrators, judge upon the soundness of, for example, the state's newly enacted legislation on sensitive matters such as the environment, public health, and the like? So there is a fundamental problem that is being raised again and again by this ideology, which is to say, three private persons cannot deal with these matters. The other extreme is the one which is criticizing the system, saying that the system is deeply inefficient, that for a dispute concerning investment to be resolved, one needs to wait for 5 to 10 years. And this is a denial of justice. So it is ridiculous that investment tribunals are those today dealing with denial of justice questions because they are denying justice themselves. That's another ideology which is problematic. So the first sentiment that comes from the book is, this is a book leaving aside these ideologies and trying to get an objective analysis of the problems of the investment arbitration system. The second thought that comes when one reads the book is that we should not forget the history of the investment arbitration system. We now criticize it, but we forget two main incredible developments in international law. The first, which we all know, is that thanks to investment arbitration, private persons, citizens, investors may have access to justice against the state directly. I mean, we have repeated that I don't know how many times. We have said we no longer need the figure of diplomatic protection. This is a big conquest under international law, and we should remember it. Investors are often multinationals, but we have all seen physical persons having problems also in host states because they were mistreated. That happens as well. So that right is an important right that we need to preserve, of course, under some limitations and requirements. And the other historical conquest that the book mentions is the Exit Convention. We may not like the Exit Convention in many respects, but the fact of the matter is that more than 150 states signed and ratified that convention, which puts forward a system for resolving disputes. We know that as we speak, Exit is trying to think of a reform of the system. They have been working on that for more than a year now. We'll see what Exit will come up at the end. But these two conquests need to be remembered. That's the second idea that comes from the book. So the third idea that comes from the book that I find very, very important is that the authors here put the following question. What is the real problem of the system? What is the first problem we need to solve for the system to be sustainable? And they say the problem is, as was mentioned by the Secretary General, the access to justice. And I agree. This is a big problem in investment arbitration. If you see, for instance, the states which have withdrawn from the ICTY Convention, one of the reasons they gave to leave the system was precisely that the state could not make counterclaims in the investment arbitration system. And hence, it was a unilateral system of dispute adjudication and defective because it wasn't reciprocal. Now, the authors do not limit themselves to raising problems, but they propose solutions. But before going to the solutions that Jackson will explain later, I think we need to enter into the problems more in depth. And there are three issues that I wanted to mention very rapidly. The first issue, and I think it's an important issue, is that the access for investors themselves to the system has become very difficult. And why is that? Why is that? Because the only way in which states can defend themselves in most of these cases is attacking the very jurisdiction of the investment tribunal. Most of the defenses that the states do have today are aimed at denying jurisdiction of the tribunal. What are those? The investment is unlawful. The dispute is contractual. It's not about a breach of a treaty, and so on and so forth. Why the states concentrate so much on defending themselves that way? Because they cannot counterclaim. They cannot put forward an alternative case against the principal case made by the investor. And I truly believe so. Only in exceptional cases, the state has been able to raise counterclaims, and in some cases, environmental counterclaims with some success. That has been exceptional. And why was that? Because the investor had commenced the arbitration not only on the basis of a treaty, unilateral arbitration, but also on the basis of a contract. And obviously, because there was a contract with an ICTY arbitration agreement, the respondent state had the right to file a counterclaim. So I think we need to keep in mind also that for investors, the access to the system has become very difficult. Many of these jurisdictional objections are very powerful, and I believe the statistics tell us that at least in 50% of the cases, the state wins on jurisdiction. That is an incredible statistic, if you think of that. Coming to the very ugly case that Cherie mentioned, the Philip Morris case, and we all agree that that case is a shame. Well, something good came out of that, because the award is a very interesting award about abuse of process. But now what I see is that abuse of process is becoming the new powerful argument of states to deny access of investors to justice. And my prediction is that this French idea of abus de droit, abuse of rights, will become the new weapon that states will use in these proceedings. And why they will use that? Because they don't have counterclaims, they don't have the possibility of putting forward an alternative case. So the second issue is, first, investors need to have access. But for investors to have access, we need the states to be less demanding regarding jurisdiction. They need to accept to litigate the merits of the case before the investment tribunal. And this is where the book, in my view, puts the finger in a very important issue, which is states need to be able to file counterclaims and really to fight the merits as we can do it in any commercial case. There is a sub-point here, which is we don't want multiple proceedings on the very same factual matrix. We would like to have all disputes relating to an investment solved before the same forum. That makes sense. Otherwise, we will have state proceedings, arbitration proceedings, and that, the book says, is bad, and we all should agree with that, in my view. And the last point, which really happens in practice in cases regarding the environment or public health, are the cases in which the home state or the citizens of the host state should participate in the proceedings. We all know about investments that caused heavy contamination in the Amazon region in Latin America. It is true that those cases would have been very different if the affected individuals, the citizens suffering from that contamination, could have participated in the proceedings. But as we speak, nobody had imagined mechanisms for that. And we'll see the models that our friends propose to overcome that problem. So I would conclude by saying that the four models proposed by the book to solve the problem of lack of access to this international justice is a very interesting proposal, and I think we can try to implement it without reform of the treaties, and there are some ideas that are put forward for that, and we can also implement them with new treaties, as we know that many states are trying to renegotiate the existing treaties. One last point. Cherie mentioned something that made me think, and that also comes from the remarks from Koffi. I think what is happening with investment arbitration, as you said, and you suggested, is a failure of the arbitration community. I cannot deny I belong to that community. And it's true that we have thought the problems of investment arbitration as technical problems. So how can we accelerate the proceedings? Should we have less hearings or less memorials? Or how could we do this and that? But we haven't thought the issues from the big picture. And I think time has come for all of us to follow the example of these gentlemen and look at the problems from the big picture. Thank you. Gentlemen.
Well, let me just say thank you again, Eduardo, for your comments, and also for chairing this this panel. I would like to say, well, first of all, I must say that I really want to have the opportunity to read your written commentary as soon as possible, but you know, I have to wait. Those are the rules. But in any event, what you just said, all the elements that you just said, are extremely important. I believe that you just wanted to state certain of the issues that will be coming in your book commentary, and I will not get into much detail on what the specific items that you have emphasized in your presentation. We do have some. Well, I think that I have to say that I agree with all your comments, and I believe that if merit will be found in this book, I think, is that it tackles a number of issues that have been there forever from the very beginning, and that people, including myself, because I'm also part of the arbitration community, we were focusing on basically making the process, the way it was being conducted, more efficient, as opposed to really questioning what exactly we're doing, whether we are really doing investment arbitration or is this investors arbitration, or whether we're doing arbitration at all, or we're deviating from that. We may offer some comments on that specific issue, but I just wanted to emphasize that point, which I think is very, very important. Thank you.
Sure. I think, as usual, Eduardo's elegant remarks have left us speechless, but I'll try to pick it up and also, at the same time, pick up the scorpion that we put down a moment ago. I think you've really focused on a key point there, which is this idea of counterclaims by states, and that's precisely why we have hope for some of the ideas here, whether the ones that we've put forward or the ones that they inspire going forward, is how do we exactly start creating a system that allows for those kinds of claims there. And what is inspiring or encouraging is that we are seeing the kinds of counterclaims, or at least the constellation of circumstances where it can happen. The case, such as Urba said, where the tribunal finds a creative way to start to address these issues. The new treaties, or at least models, that are starting to think about investor obligations and then finally saying, wait, we're creating these investor obligations, shouldn't we create a workable dispute settlement mechanism for them as well? And this gives us hope. I think that this will find some traction in the future. I think to once again pick up that scorpion of we left human rights towards the end, I think the additional challenge that we took upon ourselves in this book, although we really have only scratched the surface, is obviously this in the abstract is going to be very scary for investors. The proposition when left in the abstract is undefined, potentially unlimited claims and liability. And so one of the things that we tried to do in the book was to define, well, what are we talking about here? And frankly, where can we point to say, look, there actually is a definition of internationally recognized human rights that already exists in the UN Guiding Principles. There is a definition of what the 8 core ILO conventions are, and they form the Declaration of the Fundamental Principles and Rights at Work. We can define, the US model BIT includes a definition, quote unquote, of what is environmental law, that they intend to be taken out of the race to the bottom in terms of standards. And that's, I think, that last piece of the puzzle that we tried to throw in there in terms of trying to say there are some benchmarks that we can use here as well to avoid that idea of a scary new world of undefined claims and unrestricted liability. And I think we can only hope for more cases that whether by happenstance or design, finally find situations where host states find themselves saying, I actually have something to achieve here, not just a purely defensive claim, as you put it.
Well, Martin has come out and said it. This is perhaps scary to investors. So since he's broken that seal, I'll perhaps say a few words. And it comes out maybe most of all in the title. You know, after we chose the title, you know, I saw the first kind of production of the cover from CUP, and I sat back and I said, investors are, you know, going to think that, you know, we are not their friends when they see this title. You know, nobody likes to be arbitrated, right? I mean, we could have called the title, you know, Auditing International Investors, and the effect or the reaction might have been somewhat the same. But the point only I want to make is I do sincerely believe that, you know, for those who are willing to take perhaps a bit the longer view, the mechanisms here are for use by all. So that's how I would. Thank you, Eduardo.
Thank you, gentlemen. Any additional comments? So we have a space for comments or questions from the floor, especially for our authors. If someone wants to put a question, make a comment.
I suddenly thought maybe it would have been less scary if you said arbitrating the conduct of international investments rather than investors.
The return. So let me ask 3 final questions to our authors, and then we'll give the floor to His Excellency, the Ambassador of Peru to the Netherlands, for the closing remarks. And my first question that we have announced, I don't know how many times now, goes to Jackson. Jackson, you propose in the book some procedural mechanisms to overcome these issues that we discussed about access to justice, and you call them the 4 models, like the 4 knights of the book. Could you please explain to us these models?
With pleasure, and I will endeavor to do so with some brevity. I know that we are approaching the end of our allotted time here. However, since we produced these diagrams, I'm going to show you a series of 8. And in this first one, you know, and the point here, I hope being clear, we are not reinventing the wheel. So, you know, by the first Roman numeral, that's the arrow that comes from the top right down to the bottom left. Here you would have claims by the host state itself. So it could be a counterclaim, you know, once an investor has brought his initial claim, or it could be, at least in our models, an affirmative claim or a unilateral claim. And then in those cases where you have substantive rights, human rights, for example, that may be held by individuals or host state nationals, that's where you have, oh, excuse me, this is entirely the wrong diagram. Forgive me for that. Forgive me for that. Okay, so claims by the host state itself, it is still the arrow from top right to bottom left as I began. And then claims by the host state national itself, or the host state nationals, collectives or communities thereof. This is Roman numeral 1, from the bottom right corner to the bottom left corner. I'm going to neglect Roman numeral 2 for now, so I'll keep you in suspense, and you'll have to read the book to hear about that one. This one we have called the espousal model. So this is the second of the 4 models. It's sort of what we've called a form of reverse diplomatic protection. So we've adopted or adapted a term of art and an institution in international law. Here, actually, you would have the host state taking assignment of rights which are held by the nationals, and the host state then itself acting to prosecute those claims vis-a-vis the investor. This one we've called the Kitam model. It was suggested to us by one friend that we, you know, choose another name instead of a Latin name, but unfortunately it was too late in time. So I'm sorry, we have to carry this baggage. But this is what is sometimes known in some jurisdictions as the People's Attorney General sort of action, whereby individuals, private citizens, actually are appointed as representatives of the state to prosecute the state's own claims. So that's the model that's reflected here. The last of the 4 models is called the hybrid. and it is called the hybrid because it's sort of a merging of the prior two, the espousal model and the qui tam model. What I mean there is that a host state national can first assign his claim to the host state itself, and then the host state might in turn appoint that national to be its representative, its people's attorney general, for purposes of prosecuting the claim. There are factors and reasons various for which host states and their nationals might choose one or the other of these models. There too, I fear you will have to read the book to see. In terms of gaining jurisdiction, I think that perhaps I will neglect also these diagrams for now. It's a very important part of the book, but I know that I'm one of the last things standing between everybody and the cocktail reception. So please feel free to approach me if you like, and I'll be glad to tell you about the last 4 diagrams. But most importantly, I wanted to be sure to show the 4 models. That is what is most central. Thank you, Eduardo.
Thank you, Jackson. And you will see that at the end of the book, there is proposed text to implement the different models that the authors are proposing. Second question goes to Martin. Martin, one may have the impression, in reading the book, that the book is very procedural in nature. But I take it that there are some substantive rights that you want to underline and enhance through the book. Can you please elaborate on this point?
Sure. I think this gets back to that million-dollar question of exactly what are going to be the claims that are put forward here. And I think the broad message that we put forward in the book is to not take a very defined position on that question. It can be, or it is something to essentially be left to those who choose to take up these models and put them to use, to decide exactly what they're going to do with them. They may, for example, take inspiration from the Bangladesh Accords and say, here, fire and work safety are our concerns in a defined site, in a defined industry here, and that's where, once again, these various different stakeholders, these various different players are able to come together and come to an agreement on these are going to be the claims that we all agree should find a forum in arbitration. On the other hand, obviously, I think we have found a little bit of a consensus on just the basic idea, access to recourse, the third pillar of Ruggie's framework, the universal aspiration of human rights and indeed justice and other fields would want to seek the broadest possible scope of claims. But the million-dollar question is, well, where are we going to be able to define those sufficiently so that we're not scaring off investors and, in fact, having them, having forward-thinking investors actually be willing to sign up, in some cases precisely to obtain certainty and finality of these claims, because, of course, if they have themselves chosen to put very important claims forward before a tribunal of 3 random individuals, no, people that they have entrusted with extremely important claims, why shouldn't they be willing to go the extra step and say, these individuals should in fact be entrusted with deciding the claims that might be presented against us as an investor? We have an interest in certainty and finality there as well. And that goes back to some of these definitions that might be found in the UN Guiding Principles, in the OECD Guidelines on Multinational Enterprises, what may come out of the Human Rights Forum, the working groups that Cherie was mentioning, and in fact the process, the multilateral process that's going on right now in Geneva, perhaps pushing the envelope forward in terms of the substantive business and human rights. I think I'll leave it there.
Yes, Judge Afande.
I think one of the forces of the book is to leave that question open, but it was already apparent in the title when you say conduct. But the conduct which you want to arbitrate will determine substantive rights which is affected. I think it is something which is also to the advantage of the book, that it doesn't give the impression that it is only selective or selected substantive rights which can be defended, but it gives the impression rather that whatever the substance is, this procedure can help you to up to you to see which models you find more appropriate or not. I don't know if it's something where I am, but that's the way I understand is also that conduct says everything on the substance of the right which can be claimed. Thank you.
I don't think I could have said it better myself, so I think we do have our next co-author for.
And my last question goes now to Jose Daniel. Pepe, to close the debate, how would you summarize the key contributions of the book to the current discussions status of the investment arbitration system?
Well, that's something that has already been said to a larger extent. Let me just say a few things that I want to make sure that we can underline. First of all, yes, we agree with what you, Eduardo, and other panelists mentioned with respect to the fact that the discussion today, the credibility crisis of the system is, in our opinion, also ideologic. It's basically an ideological deadlock that we are in, and that the book is trying to underline that and take it to a different scenario and basically reason as lawyers with respect to the main issues that are in discussion with respect to investment arbitration. The second issue is that we believe that the reform can and should come from within. We don't think that all these decades of relative success of investment arbitration, at least with respect to claims by investors against home states, and its effect in promoting investment, can be just be forgotten by new ideas and new initiatives. On the contrary, we believe that we need a reform from within. Another thing I wanted to underline is that one thing we do in the book, and this also goes to something that was mentioned by Cherie, is that we in the book challenge the conventional belief that there is no means to gain the consent of the investors or the home countries. And we try to make the case for that. We submit that investors have an interest in allowing for claims of host states and their nationals to proceed in a known territory, such as investment arbitration. As in any business deal, the success of investment transactions requires some form of adjudication, and I think that we all understand that that is a better alternative compared to going to home state courts or host state courts, which is what we know has been going on if actually a legal remedy is sought by the population or the home country. The next thing is really, and in simple terms, investment, the book submits that investment arbitration must be more about investment and more about arbitration. By saying so, what I'm trying to say is that more investment shall mean that the interests of more stakeholders in the investment equation shall be taken into account. By more arbitration, we refer to restore the mutuality of access that is in arbitration's essence. So there is, those two words summarize a lot of what we are trying to accomplish through the book. It is true that in today's global scenario, we cannot continue assuming that the investor is always the David. But international law needs to protect against the Goliath host state. I mean, clearly that is not the case any longer, not in a world where 69 of the 100 top economies are corporations. So there is something that we try to elaborate on in our belief that we can continue building on the system and that perhaps this is the time to do it. Let me just finish with one quote. Sir Winston Churchill once said, "To build may be a slow and laborious task of years. To destroy can be the thoughtless action of a single day." I believe that phrase captures a lot of what we're trying to do here. We encourage all stakeholders, and instead of focusing on destroying something that has been so difficult to create and that, again, has achieved some success, enough to have some of the finest legal minds defending the system, cannot just be forgotten, cannot be just ruled out as a bad option to resolve investment disputes. On the contrary, we believe that all stakeholders should continue working together in building over that platform, as Sir Winston Churchill suggests in that phrase. So, frankly, other than those minor additional points that I wanted to make, I think that everything has been on the table, especially thanks to the great panel that we have had. So we really appreciate your presence and your advice and your comments. And I speak for my co-authors as well. So that would be my response, Mr. Chairman.
Thank you, gentlemen, and thank you for the book. Now, if I may invite His Excellency, the Ambassador of Peru to the Netherlands, for his closing remarks.
Don't worry, it will be really short. Excellencies, dear authors and panelists, ladies and gentlemen, I do hope all will agree that we have seen a rich and engaging exchange of thoughts and ideas here this afternoon. Personally, I would like to say that I will gladly convey these worthy ideas to my government. Unfortunately, I am the one to tell you that Judge David Kern, who wrote the foreword to the book, has not been able to join us as the United States Claims Tribunal remains in session, and its current hearing was unexpectedly extended. So it now falls to me, on behalf of the Secretary General, to have the honor of to thank our panelists, and I will invite Jennifer to convey that gratitude with a small gift. Once more time, Thank you, everybody. And I now invite you all to join us in the main floor, in the main hall for the reception. Thank you.